Good morning, Your Honors. The matter before the court today is the case entitled Robert Lafayette versus Blueprint Basketball et al., case number 24 AP 127. Appellant Robert Lafayette is self-represented and is appearing here today. Representing the appellee, Blueprint Basketball, is Thomas Nuovo. Representing the appellee, Sam Jackson, Vermont Elite, and Joseph Neal is Alexandra Esposito. Appellees will be splitting time today.
Okay, thanks for that explanation. I appreciate it. And Mr. Lafayette, can you hear me, sir?
Yes, Your Honor.
Okay, and we can hear you. You understand you have 5 minutes?
I've been advised.
Okay, and we will try to give you an alert when you've got about a minute left. So please go ahead.
Thank you. I appreciate the court's time today. This case challenges the misapplication of the Vermont Consumer Protection Act and procedural errors that denied myself a fair trial. As a parent who paid for services from Blueprint Basketball and VT Elite, I am, of course, considered and must be considered, like other parents, a consumer in this ever commercialized youth sports industry. In that end, I asked the court to remand this case for a full trial. Parents like myself spend thousands annually on youth sports programs. It's a $19 billion with a B industry and markets itself to families promising development and future opportunities. The trial court's narrow interpretation of consumer doesn't reflect the reality of parents' financial investment or their participatory interests. Blueprint's slogan, moreover, skills over politics, was a separation from the standard unfortunate elephant in the room, which is that oftentimes merit-based skill takes a backseat to nepotism, favoritism, and that sort of unfortunate elements that are present in youth sports. They promised to...
Mr. Lafayette, I mean, to interrupt you, but is that what the slogan means? Is that that influence on decisions on playing time and the like? It's skill over politics. Is that
that's
your
absolutely
understanding?
Oh yeah, absolutely. It was a new path forward, a new light. It was a paradigm shift because for far too long, and we've all seen it, where it's like the parent's kid pitching always gets to pitch and you could be there for 4 or 5 hours and it's not merit based. And so when you're going to say, hey, we're going to put skills above all of that, that was a paradigm shift. And that's what convinced me to enroll my son.
Please go ahead.
Oh, okay, sure. So after I raised legitimate concerns, however, and criticisms, my son was banned, not due to his skills, but in retaliation for the criticisms. And I allege that this is a clear deceptive practice, promising one thing, skills over politics. When criticism comes, you're out, not based on skills. This is exactly what the VCPA was designed to prevent. As Vermont versus ExxonMobil demonstrated, consumer protection law should be applied broadly and youth sports ought not to be excluded. There's been serious damages. This case is not just about deceptive practices, but about real harm. My son and I have suffered severe emotional distress, physical manifestations, leading to hospitalization. The emotional and physical toll on our health is undeniable. The financial losses are equally significant. We pay non-refundable fees, incur travel expenses, lodging, purchase merchandise from the club's 24-hour online store, which sells you anything from a parka to a backpack, all with the Blueprint logo, all with the VT Elite logo. And we are constantly marketed as families, and we, due to the behavior of Blueprint, lost an opportunity to join VT Elite after a false statement was issued about us, and to which has never been provided to us. The trial court even failed to allow us to have discovery. And the trial court failed to recognize these damages, even though they are real and they are crucial under the VCPA. And finally, judicial recusal and procedural errors are important to note. The trial court made procedural errors. After I filed my notice of appeal, the court continued hearings, even though it was no longer its jurisdiction.
You have 1 minute, sir. You've got 1 minute left.
Thank you. Additionally, Judge Torr was recused due to impartiality concerns raising questions about the fairness of the summary judgment. The procedural flaws alone, I would argue, demand a remand or at least consideration thereof. And I would hold the rest of my time for a rebuttal.
Okay, thank you very much. We'll hear who's going to go first for the appellee.
Thank you, Your Honors. That would be myself.
All right, counsel, please introduce yourself, identify your client, and then proceed.
Thank you, Your Honors. My name is Thomas Nuovo, and I have the honor of representing Blueprint Basketball, Kara Caswell, Brian Robertson, and myself, who was originally brought in this case. What the trial court did was find that that Kara Caswell, Brian Robertson, myself, and other of the defendants were not consumers. I'm sorry, we're not Mr. Lafayette was not a consumer to those individuals because he never purchased anything from any of those individuals themselves. Technically, only Blueprint Basketball would have been a consumer had he actually paid for the services. The issue here is controlled by Fody Fuels. This is basically a dispute between Mr. Lafayette and the organization, which he admits in his complaint after he was removed from a basketball game at which Blueprint was participating, and then they asked him not to attend practices. And then after he sent a series of emails, they asked him not to. They ended up asking his son not to be there. This is exactly the type of personal interaction. It has nothing to do with commerce, and therefore the Consumer Protection Act does not apply. The skills over slogan, skills over politics is just a slogan. And it doesn't apply.
What's it mean to you? What's that slogan mean to you?
Well, to me, it is just a slogan that sort of promotes that we're going to try to promote the best kids within our program. But it talks about, if anything, it only applies to playing time. It doesn't apply to having to deal with parents who are being abusive through emails or have been faulty in how they behave themselves at games. That's what this is about. He was not removed because of his son's practices and skills, but rather
You have 3 minutes. 3 minutes left, Mr. Noble.
Yep. So that's all I really want to say. I really think that the Consumer Protection Act does not apply because the actions that he's complaining about did not occur in commerce. So I would give the rest of my time to my colleague. Thank you.
Okay, thank you very much. We'll hear from counsel for the second appellee. Please, counsel, introduce yourself, identify your client, and then proceed.
Thank you. Thank you, Your Honors, and good morning. My name is Alexandra Esposito. I'm here on behalf of appellees Vermont Elite, Sam Jackson, and Joseph McNeil. I would just like to assert that, Mr. Lafayette, you just heard speak, but really what should be examined here is the complaint that was filed on December 3rd. And you will see that Mr. Lafayette failed to allege any facts purporting to, Sam Jackson, Vermont Elite, and Joseph McNeil, other than bare assertions that there was email communication and that they worked in concert with Joseph McNeil, and that these are not enough to rise to any sort of protection under the Vermont Consumer Protection Act. I, rely on the written submissions, and I, have nothing further unless there are questions from the bench.
Okay. I don't see any hands, so thank you very much. We'll turn back to the appellant. How much time does the appellant have, please?
Appellant has 1 minute, 6 seconds remaining.
Mr. Lafayette, did you hear that?
Yes, sir. Yes, Your Honor.
Okay, please go ahead.
I would just like to reframe, argue that the position of myself is that, of course, this all happened in commerce. The transactions for jerseys that are hung in my son's room, of course, were purchased. The only year that I don't think fees were paid in full was the last year that we were with the program, but previous seasons, of course, were paid. And of course, all of this gave rise in commerce. And I would argue it's the hub and spoke, that the hub is these clubs and the spoke is extra training, more uniform, backpack, buy your socks here, buy this here, extra training here. And it all goes back to the hub, with each spoke being another commerce offering. You pay for it with a Visa or a MasterCard. And I truly, truly believe that parents in this continuing expanding industry deserve the protections of the Vermont Consumer Protection Act. And I also argue that the framing of the reasons for my removal are been exaggerated today by Mr. Nuovo, greatly exaggerated. And with that,
Okay. All right, I see your time has expired, so thank you.